Name is Umesh Rao. Today's subject is Payment of Gratuity Act 1972. The subject is covered under Labor Law 2. In this class, we are discussing what is gratuity, what Constitution of India says, why gratuity is required, what is the problem in India, and gratuity scheme is applicable to which are all the sectors, what is the wages for the purpose of calculation of gratuity, who is employee under gratuity scheme, what is the eligibility to receive gratuity, when gratuity is payable, what is the meaning of continuous service, nomination under gratuity, and forfeiture of gratuity. What is gratuity? Gratuity is a free gift. It is a donation. Anything given without obligation. This is dictionary meaning. Gratuity and the Constitution of India. What Constitution of India says? Constitution of India says that state shall provide suitable legislation or economic organization to all the workers. These workers may be agriculture workers, industrial workers. All should be given living wages, not minimum wages, and condition of work and decent standard of life, full employment, leisure, and social and cultural opportunities. What is the object of the gratuity scheme? The Gratuity Act 1972 came into operation with effect from 16th September 1972. The object of the Act is to provide retiring benefit to the workmen who have rendered long and unblemished service to the employer. The claim of gratuity can be made only on the date of retirement on the basis of salary drawn on the date of retirement. The concept of pension scheme, provident fund scheme, and gratuity, they are different from each other. They constitute different classes. The gratuity shall be payable to an employee on the termination of his employment. He has to render continuous service of not less than 5 years. It is applicable to all such establishments in which 10 or more employees are employed in any day of the preceding 12 months specified by the government, or shops and establishments shall continue to be governed by this act even number of persons falls below 10 if it is notified by the government. The gratuity amount is 15 days average pay for every completed year of service at the rate of 15 days wages. It is calculated by dividing the monthly rate of wages by 26 and multiplying the quotient 15. Why gratuity is required? What is the problem in India? In India, wages paid are minimum wages. India, wage is not sufficient to meet their expenditures. When their wages are very meager, due to inflation, money value further comes down and they cannot save for their future. Workers spend their whole life in factories, and retirement benefits are not sufficient. They get very little amount of retirement benefit. It is not sufficient to meet their family needs. Worker has to perform marriages to his children. Worker has to construct a small house. Worker has to look after family. So, therefore, Parliament enacted a Payment of Gratuity Act 1972. Application of gratuity. This act applies to factories, mine, oil field, plantation, port, and railways. Second, every shop or establishment in a state where 10 or more persons are employed on a day in the preceding 12 months, gratuity is eligible. And third, such other establishments in which 10 or more employees are employed on any day of the preceding 12 months specified by the central government. Fourth, shops or establishment shall continue to be governed by the Act even number of persons falls below 10 if it is notified by the government. So, payment of Gratuity Act is a benevolent piece of legislation. Even if the claim is not made in the proper form, the same will not take away the right to the claimant to prefer claim. So, which are all the organization, for example, covered under gratuity? Society registered under the Societies Registration Act would be establishment covered under Gratuity Act. Minority institution, as per the provisions of the Gratuity Act applicable. Local bodies, local authorities created under the Delhi Municipal Corporation is an establishment governed by the payment of Gratuity Act. Gratuity law applicable to establishment, shops, commercial establishment, and also non-commercial establishments also. For example, BD workers are entitled payment of gratuity and management is liable to pay the same. Even educational institutions such as university carrying on systematic activity by employing more than 10 persons are establishments under the Gratuity Act 1972. So, payment of Gratuity Act applicable to every shop or establishment within the meaning of any law. The establishment within the meaning of Contract Labor Regulation and Abolition Act 1970. It is also an establishment and they are also entitled for gratuity. Now, question is, in order to claim gratuity, who is an employee? Employee is entitled to get the benefit of gratuity. No? Employee means any person employed on wages in any establishment, factory, mine, oil field, plantation, port, railway, shop. What he is doing? It may do skilled work or semi-skilled work or unskilled work or manual work or supervisory work or technical work or clerical work. So terms of the employment may be express or implied. Employed, he may be employed in managerial capacity or administrative capacity. It does not include person who hold the post of government or any other act. What is the wages for gratuity scheme? Gratuity shall be payable to an employee on the termination of his employment after he has rendered continuous service for not less than 5 years of his superannuation, retirement, resignation, death, disablement, or disease. So, wages means all emoluments which earned by employer while on duty or on leave in terms of conditions of his employment which are paid or payable to him in cash. Wages means it includes dearness allowance, but it does not include bonus, commission, house rent allowance, overtime wages, or any other allowances. So, what is the eligibility to receive gratuity? Gratuity shall be payable to an employee on the termination of the employment after he has rendered continuous service for not less than 5 years on his superannuation, retirement, resignation, death, disablement, or disease. So, gratuity amount is 15 days average pay for every completed year of service. Minimum period of continued service is 5 years. It is calculated by dividing the monthly rate of wages by 26 and multiplying the quotient by 15. So gratuity is not payable every year. It is payable at the end of the service. So when gratuity is payable, first one, superannuation. Superannuation, it is a retirement. Gratuity is a retirement benefit. It helps him for his old age. Retirement is fixed in the contract. It may be 58 years or 60 years. The age of superannuation is fixed 58 or 60 years. So gratuity is payable when an employee actually retires from service. Second one, retirement. Retirement means termination of the service of an employee other than superannuation. This covers dismissal, removal, retrenchment. Third one is resignation. Employee may resign from his job with his pleasure. He should not violate the terms of the contract. Forced resignation is not resignation, it is dismissal. Death. Gratuity support the employee at his retiring age. It helps him for his family. If the death of the employee occurs, the employer should give gratuity to the aggrieved family. In case of death, after completion of continuous service of 5 years. Disablement due to accident and disease. If worker gets disablement or meets an accident, he is eligible for gratuity. Continuous service. What is the meaning of continuous service? Before that, we should know what is the condition for payment of gratuity. Gratuity shall be payable to an employee on the termination of his employment after he has rendered continuous service for not less than 5 years. Here, three elements are there. One, gratuity is payable to an employee after rendering service of 5 years. Gratuity payable on his termination of employment. Third one, he should have rendered continued service for 5 years. What is the meaning of continued service? Continued service means uninterrupted service. There should not be any break in the service. Now, what is the meaning of uninterrupted service? Uninterrupted service includes sickness, accident, leave, absence of leave without leave, layoff, strike, lockout, cessation of work not due to any fault of the employee. Now, forfeiture of gratuity. What is the meaning of forfeiture of gratuity? It means employee, employer need not pay the gratuity to employee. Employee is not eligible to receive the gratuity. Why? What is the reason? This is because of the major misconduct of employee. Employee is terminated for any act of willful negligence or omission. It causes damage to the property of the owner. It causes loss to the property, destruction of property. Or employee is terminated for any act of violence. Or employee is terminated for an act of moral turpitude. So what is the condition for not paying gratuity? Misconduct should have done by employee during the course of employment. Second, burden of proof lies on the employer. He has to prove employee's misconduct. Third, employer should follow the principles of natural justice. First, he has to issue notice, show cause notice. Second, he has to give personal hearing. Third, reasonable opportunity should be given to defend himself. Third, appeal should be given. These are all the conditions necessary for the forfeiture of gratuity. Gratuity and nomination. What is the nomination? Nomination means an employee nominates any person as a candidate to receive the gratuity benefits from employer in case of death. What is the condition for nomination? Is there any conditions? Yes. employee is at liberty to nominate his wife and children to receive the gratuity benefit. Once nomination is made, he can change the name of the nominee. He has to give written notice to employer. He can nominate more than one family members and distribute gratuity amount. Can an employee nominate any person who is not a family member of his family? No, it is void. Employee cannot nominate any person who is not a family member. Now, what is the position of the gratuity amount if nominee dies prior to employee? In such case, interest of the nominee revert back to the employee. It is employer's duty to keep the nomination papers in safe custody. When nominee can claim the gratuity amount, nominee can claim the gratuity amount, then nominee shall submit application within 30 days from the date of gratuity become payable to him. Penalties for employer who gives false statement to avoid payment of gratuity. Employer knowingly gives false statement to avoid payment of gratuity are liable for 6 months imprisonment or fine of rupees 10,000 or both. Or employer contravenes any provisions or defaults any order is liable to imprisonment of 3 months to 1 year and fine of rupees 10,000 to 20,000 or both. Thank you.